everyone, sorry it took me so long to get this to you. Turned out I picked up a little bit of a sore throat while I was out there. But with some hot honey tea, I braved through it. And I apologize in advance because I get very irked when I talk about this document. I played it back and I thought, oh Cassidy, you're too angry. But I didn't think my throat could handle recording it again. So please bear with all of the irking. Dick, Jim, and Company, the Dirt Road Crusaders, have now filed a writ of prohibition with the Supreme Court to try to stop Judge Newman from being allowed to hear the case against Alex. Not just any case. All cases. In addition, they've filed for the case that's on the docket for November 27th, the long-awaited Satterfield financial case, to also be called off pending the Supreme Court's decision. Personally, I think this is probably the main goal, as even they know this writ of prohibition is very unlikely to go through. They repeat themselves over and over, demanding that if Judge Newman won't recuse himself, that the Supreme Court must remove him for defaming Alex. How is calling a man found guilty in court guilty, defaming him? This writ of prohibition is 265 pages long and filled with enough slander on Judge Newman to keep us irked for days. It's a long one, so grab your snacks and drinks, and let's get started. This is Legal Updates with Cassidy. Clutch your pearls. A judge said a guilty man is guilty. Alex files a writ of prohibition. Welcome. If you remember the day of the court hearing of the trio of bad guys that I called the Beaufort Triangle, Corey, Alex, and Russell, Dick made a comment directly to Judge Newman about him not hearing the case. So, unfortunately for him, he was misinformed and the case was going to proceed in Judge Newman's court. Apparently, it's all Judge Newman's fault that Alex was found guilty. Forget the fact that he is guilty. It must be Judge Newman's fault. And this 265-page writ of prohibition, they outline why they think Judge Newman shouldn't be allowed to move forward with this case. They include transcripts and, of course, that dreaded paper and ink waster, the motion for a new trial, with the Timothy Stone Facebook garbage that has not been definitively traced back to anyone, and those useless affidavits prepared and signed by Holly Miller. As I said, I'm on a short trip, so the timing couldn't be worse. I'm out of country, so I'm not able to access any of my court websites. They only allow those accessed from within the United States. To start with, they mention Rule 245B. Rule 245 is just about jurisdiction, and B specifically is just a short paragraph that identifies that you have to serve and file a petition for a writ of prohibition. Parts A and C give us a little bit more information, especially Part A, that tells us it's sort of a last resort after all other methods have been exhausted in lower courts. Part C outlines the proper standard required for serving everyone involved. These will be returned if they're not properly filed, and it will be funny if that's the response they get yet again, as they seem to consistently have trouble filing things properly. As Part A mentioned, these require emergent or extraordinary situations. As an example, Attorney General Alan Wilson filed one back in April of this year to have murderer Jeroid Price brought back into custody. This was probably the second biggest story in South Carolina this year. A lot of you probably heard about it, so I'm not going to get into a lot of the details because this document is big enough. But a quick outline, Jeroid Price was convicted of murdering a university student, Carl Smalls, at a nightclub in Columbia back in 2002. He was sentenced to 35 years in prison, but a familiar name to you all, Tud Rutherford, and if you don't remember him, he's one of Russell Laffitte's attorneys. He's the one that looked like he was meeting a star when Alex walked into the courtroom. He shook his hand and kept smiling at him for quite a while. It was very uncomfortable and very cringe, and was really picked up a lot on social media. So he and prosecutor Byron Gibson requested an early release for Jeroid Price after he'd only served 19 years. Price had allegedly reported another inmate's escape and kept 2 prison guards from serious injury. So they put it before the court for him to be released early, and now retired Judge Casey Manning allowed it. Naturally, Small's family was outraged and voiced their concerns. Attorney General Alan Wilson objected to his release and immediately filed a writ of prohibition to have him returned. The Supreme Court upheld this, and a federal warrant was issued for him to be arrested and brought back to South Carolina. He had been serving his prison term in New Mexico after being transferred there. This brought a nationwide search for him that involved SLED, the FBI, and ultimately New York when he was found living in an apartment in the Bronx. He was taken into custody on July 12th, and on September 6th, the Supreme Court ruled that the order to reduce his sentence was outside of the circuit court's authority and contrary to law. So the lower court's order was vacated, and he was remanded back to custody and has to serve the remainder of his 35-year prison sentence. So this is the kind of situation where a writ like this becomes necessary. It was emergent, necessary, and there was no other recourse because the lower court had acted beyond its authority. Therefore, it had to be dealt with a higher authority, the Supreme Court. So it tells us the background that Judge Newman had presided over his murder trial, and that there's a motion for a new trial because of the clerk of court's conduct. I take issue with the wording saying that she engaged in jury tampering during the trial to advance her own personal interest because these accusations have yet to be proven. If you'll remember, he made a huge fuss at the beginning of Alex's murder trial, stating that Alex must be considered innocent until proven guilty, but yet he doesn't give her that same respect. Now come the accusations. He states that Judge Newman made numerous statements in violation of the Code of Judicial Conduct that require his disqualification from presiding over further proceedings in this matter. In the preamble of this code, however, it states, here at the bottom, furthermore, the purpose of the code would be subverted if the code were invoked by lawyers for mere tactical advantage in a proceeding. So, it is not intended to be used for tactical advantage, which is exactly what Dick and Jim are trying to use it for. As I mentioned and have said many times, I think it's possible they want to either get rid of a good judge in the hopes of getting one with lesser morals, or could possibly simply be using this as a ploy to waste time with the state court while letting the federal case be completed first, as an attempt to get Alex into federal prison instead of state prison. They're implying that Judge Newman went against Canon 3 of this code, that he's not impartial, and they point to times he has spoken to or about Alex. These are congratulating the jury for returning the correct verdict, statements at sentencing evidencing personal bias, and in statements in public interviews after the trial. It also says that he stated his personal opinions regarding Mr. Murdaugh's guilt, legal issues on appeal, and strategic choices by Mr. Murdaugh's counsel during trial. He then goes on to say that Alex's right to have his case heard by an impartial judge will be violated if Judge Newman proceeds to hear his motion for a new trial, and so this writ of prohibition is his only recourse. As we go through this writ, we'll compare what Judge Newman said with what is written in this code of conduct. Let's not pretend that judges don't have opinions on defendant's guilt at some point during a trial, whether it be before trial even happens, as they see a trial unfold, or even at the end. The judge will have an opinion about the defendant's guilt or innocence. It's human nature. It's unavoidable. These are educated men and women. Their ability to uphold the law is what matters. There's not a judge in this country or in this world that has heard of the Alex Murdaugh case that doesn't have an opinion as to his guilt or innocence. It's a fact. But a good judge is able to set that aside and serve their purpose to uphold law in their courtroom as the jury makes the decision. This next bit is just so bizarre to me. He's going to talk about Judge Newman defaming his client. But I think the things that he says about Alex are the worst things that anybody says. He introduces him. Mr. Murdaugh is a disgraced former attorney and drug addict. Once a prominent member of the bar, Mr. Murdaugh was charged with stealing millions from his clients and others who trusted him. Here's another weird sentence. And he gave millions to violent drug dealers. Let's talk about this. The money they traced directly from Alex went to Cousin Eddie. Beyond Cousin Eddie may have gone to the Walterboro Cowboys and that sort, Jerry Rivers, the ones we've mentioned before in videos. Alex did not directly deal with violent drug dealers. I think this is a ploy to make people think it was possible drug cartel killed Maggie and Paul. Let me finish the sentence the way he writes it in this document. He gave millions to violent drug dealers who fed his voracious opioid addiction. His law firm confronted him about his thievery on September 3, 2021. He resigned from the firm and after a failed suicide attempt, assisted by his drug dealer, entered drug rehabilitation. I don't think he could have used the word drug more times than he did, but also this failed suicide attempt. This has not been resolved about what actually happened, and when you hear Cousin Eddie's lawyers speak, they have a different take on this.
Because prosecutors are actually now saying it had nothing to do with an insurance scam. It had everything to do with Alex Murdaugh trying to make it look like there's some boogeyman out there trying to kill Murdaughs one by one. First Maggie, then Paul, and then, sure enough, Alec. But what is Cousin Eddie's role going to be? It's a good thing I have Amy Zimmercheck with me live. She is Cousin Eddie's attorney. What Murdaugh is saying now is he's saying your client actually killed his wife and his son.
It's pretty convenient, Ashley, how his stories change. I believe that's common with the covert narcissism. But I believe that when he lured Eddie out to the side of the road, he was going to kill him and blame this whole thing on him. I firmly believe that was what was going to happen.
That's fascinating. So, okay, I'm still confused because after this crazy thing happened roadside, the 911 call, the admission so quickly from Alex Murdaugh to the police that he was just trying to get $10 million in insurance money and have his cousin put a bullet in his head. The prosecutors are saying, no, that isn't what happened. Actually, what he wanted to do was make sure the whole world thought that he was a victim too, that Alex Murdaugh was a victim too. But
I and several people also wonder about whether or not this was a failed suicide attempt or an attempt on Alex's part to take out Cousin Eddie and blame him for the murders of Maggie and Paul to get the suspicions off himself, and it all went wrong. I think it's a possibility that should be considered. But back to this drug dealer thing. This is one of the things that the Lifetime movie got so wrong. They showed some violent, sketchy, scary man coming after Alex, kind of in a threatening way because he owed money for drugs. I think he took some drugs, sure, but this wild $50,000 a week for 20 years, do you know how messed up his intestines would be at this point? Like with most longtime opioid users, at some point there would have been blockage. People end up in the ER constantly when they take that heavy of opioid drugs because it stops up their digestive system. They end up with perforated bowels, all kinds of things. But to take that amount that he claims that he took for all of those years and not to have had anything like that happen is just unreasonable to believe. The fact that he never OD'd, it's all so unreasonable to try to make us believe. But it sounds like for this next murder trial they think they're going to go so hard for this drug angle, and they're getting it in print now. Another interesting thing that Cousin Eddie's lawyer has said is that he wasn't always selling Alex drugs. A lot of this was straight up money laundering. From October 8, 2019 to May 28, 2021, Alex issues 17 cashier's checks from Fake Forge to Cousin Eddie, Curtis Smith, totaling $164,748.76. And then from the personal account that he had already transferred some of the laundered settlement money to, he writes 254 personal checks to Cousin Eddie, totaling $1,825,560.95. Almost $2 million in 20 months. Alex was in a hot rush to make us all believe that he had a drug addiction and that that's where all his money went. He wanted us to think it occurred over a large span of time. Yet, his transactions with Cousin Eddie were only within this 20-month period. It's simply impossible that he spent almost $2 million in less than 2 years on Oxy, in my opinion and in many others' opinions. Also, in my opinion, something much bigger was happening with this money that has yet to be uncovered. These checks were written to him, cashed by him, and the cash returned to Alex, according to Eddie. And I think this is something that really needs to be investigated. The unfortunate thing is that Cousin Eddie is not the most reliable witness. So trying to base testimony exclusively on him is a difficult case to make. But I believe that this makes more sense. Alex was trying to get money saved up safely away that the court could not take. He knew this boat crash case was looming. He needed a way to hide money. He needed money converted to cash so that it couldn't be traced. There's a lot of theories about what happened to all of this money that Alex had. I believe there are a lot of places it could have ended up. Some of the things people think is maybe he had a big gambling problem. This is possible. It's also possible he was converting as much to cash as he could to get it stashed somewhere for the future. He never believed, and even now still doesn't believe, that he'll spend the rest of his life in prison. Buster has already messed up his path by cheating in law school. He needed money put away somewhere for the future, and he knew that any sort of bank account or any sort of property, all of that could be taken. There's no bankruptcy that can cover fraud cases, so filing bankruptcy wasn't an option. He needed money put to cash so that it could be stored or stashed somewhere. They want to make a big hype about this whole drug addiction because it explains this stashed money. Since when is being on drugs a defense for murder or any other criminal acts? It's just an additional criminal act. No judge is going to say, oh, you're on drugs. Okay, well, that's not your fault. It's ridiculous that they keep bringing up these drugs. So what is the motive behind continually bringing it up? I think it's twofold. It covers where the money went, and it gives them a possible explanation for who may have killed Maggie and Paul. That's just my opinion. But the next paragraph is even more repulsive. Back in court, only Dick spoke very insensitively about the murders. And now this same guy, in describing the murders, he described them as grotesquely and as gruesomely as he could. Everyone else was a lot more sensitive about the murders and the details of the murders, covering the screens while Alex sat there bobbing his head like some kind of weird bird. But it was Dick who would stand up there and describe the crime scene so grotesquely and gruesomely, with Buster right there in the audience, with Maggie's sister sometimes there. But he uses this to say, oh, Alex couldn't have done it because a father just couldn't do this to his own son. But he gets some other things wrong too. He says that Paul was shot at close range in the chest with buckshot and then again with birdshot while the muzzle was pressed against his skull, ejecting his brain from his skull entirely. Now, why is that in this document? That's sick. That doesn't belong in this document. But not only that, he was not shot with the muzzle pressed against his skull. This is a completely false statement. But aside from that, how did Paul's brains end up where they were? It's because that first shot, it was fired quickly within the shed, and by some miracle, it had not killed Paul. So Paul wandered out, and then that's when the gruesome shot took place. It's not like Alex said, oh, I want to blow his brains up all over the place. I want to shoot his brain outside of his head. No, the first shot was fired quickly, like a coward within the shed, stepped in, fired, stepped out, so he didn't have to see it. But like I said, by some miracle, it hadn't killed Paul, so he wandered out, and then the gruesome shot happened. He never anticipated Paul walking back out like that. But does it mean that because he was killed gruesomely that it couldn't be a father? Let's look at some recent cases. Just this year, a 16-year-old boy, Stephen Murdaugh, who lived with his grandpa. His dad came and was visiting. The grandpa left to go visit the wife who was in rehabilitation. The father proceeded to chop his young 16-year-old son up with an angle grinder in his father's home. When the grandpa arrived, the dad was outside and he told the grandpa, you probably don't want to go in there. I killed someone. But of course, the grandpa ran in there because he knew the only other person that was in there was his 16-year-old grandson, which he found literally hacked in pieces by his father with a hand-held power tool. Gruesome as can be. Fathers don't kill sons in gruesome ways, really? Here's another case we all know about, the Chris Watts case. He killed both of his little baby girls, toddlers. and he put them in oil tanks with an opening diameter of something like 8 inches. I can hardly read that story. Imagine what it took to force their bodies through such a small hole. A father of 2 adorable little girls, one of which just weeks before her death was recorded on video singing a song about her father being her hero, and he showed no mercy to his own little tiny baby daughters. And then after doing it, shoves their bodies in this big old oil tank. So don't tell us that a father is not capable of shooting his son. 3 women are killed every day in the United States by their partner or ex-partner. Every day, 3. On average, more than 1 child is murdered by its parent every day, mothers and fathers almost equally. Who are these people? Are they some kind of homeless derelicts, some crazy people out there, drug addicts like Alex? No. There's another case of a chiropractor from Connecticut who went down and killed his family in Florida. He was living in Connecticut and would go down on weekends to visit them in their home in a Disney-owned property. Why did he do it? His finances were in ruins, that's why. He was living beyond his means. He was about to lose everything, just like Alex. So he killed his wife and his children and was living amongst their dead bodies for weeks. You can't say because it's shocking, it didn't happen. It happens, unfortunately, every day in this country and around the world. So try again, Dick Harpootlian. That line of reasoning does not work. The next paragraph, he talks about the motive of finances, about Mr. Murdaugh's many financial crimes which were otherwise unconnected to the murders. How do you take the motive out and say the motive is unconnected to the murders? It's the motive. How is it unconnected? It also shows the pattern of behavior of a desperate, spiraling man. He calls the evidence circumstantial. But it's outlined in the rules of the court that evidence can be circumstantial and still lead to a guilty verdict. He says a lot of this circumstantial evidence is inconsistent with them being guilty. That is simply not true. He says Alex only had about 11 minutes to clean up. He had 19. He says the water hose was seen in Paul's video in the exact manner it was found later. But in Paul's video, we hear the hose come on. We hear the water running. And we see in the crime scene photos how much water is there. That hose was in use. In the footnote, he talks about Alex's clothes not having any blood on them. But this lack of blood is evidence in itself because Alex claimed that he touched both of them, checked for life, checked for pulse. How did he do this and have 0 blood on him? In Mark Ball's testimony, he walked around the crime scene the next day and inadvertently got blood on both his shoulders and his pants. The bodies had been removed at this point, yet Alex got no blood on him at all? He talks about unidentified male DNA being discovered on Maggie. That's misleading. Under one of Maggie's fingernails, there was a teeny tiny fraction of male DNA. But we know that Maggie had just come from getting a manicure and a pedicure, and that's probably where that came from. And it was such a teeny tiny amount, it could hardly be evidence of her coming in contact with her murderer. Her body also clearly shows no defensive wounds. She didn't get close to her attacker. The first shots to her were far off. By the time the shooter was close to her body, she was down, close to death. She didn't touch her killer. They also say Maggie's phone was thrown during one of Alex's calls, suggesting that the people who were holding her phone got scared and threw it because he called. But the fact is, that phone alerted to being turned just before Alex made that phone call. Just like if you're holding 2 phones in your hands, you pick one up and you start calling with the other. What are the chances of someone else just turning the phone as Alex started to call? Why would they have taken Maggie's phone in the first place? Why not take Paul's phone? If this was about the boat crash, he would have been the prime suspect. He would have been the prime target. He and Alex, not Maggie. Why would they need Maggie's phone? They mentioned not seeing step data that shows the phones moving together, but we know that Maggie took her phone down to the kennels and Alex left his at home. Of course they're not moving together. It talks about the phone calls that Alex made to people as he drove to and from his parents, and that everyone thought he sounded completely normal. But do you know when else he seemed completely normal? When he lied to his clients about their money. when he lied to his law partners, when he lied to Jeannie Seckinger, when he lied to his family, when he lied to the police about being at the kennels. We watched him lie to the police effortlessly on dash cam videos and body cam videos. Alex knew how to lie. Alex knew how to pretend. He and his defense team claim he was so hopped up on opioids that it was costing him $50,000 to keep up that habit. Not one person around him noticed anything odd. Not even his brother who worked with him in the law firm together every day. Not his dad. No one? So they're saying Alex was that masterful at hiding things. Of course, he could call people on the phone and pretend everything was completely normal. We watched him go from crying in front of the police to asking a new officer who walked up on the scene, "How you doing?" Completely normal. We watched him during the trial know how to turn it on and off, bobbing his head, bobbing his head, bobbing his head. He's a master manipulator. He knows how to turn his emotions off and on. Of course he could make these phone calls like nothing happened. It also mentions that everyone that knew him said they had a normal, loving relationship. No, that's not true. Her sister said there had been cheating and that Maggie was still struggling with it even though it had been like 15 years before. Blanca said that Maggie had expressed worries about finances and was afraid Alex was hiding things. Paul's girlfriend Morgan described a situation after a wedding where Alex had taken a pain pill and became very mean. So mean, she didn't even want to take him home. She took him and dropped him off at his parents' house. Like, you deal with this. You made it. Does that sound normal? Does that sound loving? We know from multiple people that Maggie had to be talked into going to Moselle that night, so this was not some normal, loving relationship. Next, they mention that Judge Newman admits that admitting the financial testimony was pretty controversial. But admitting that something is controversial doesn't mean that it's wrong. It means that people are going to talk about it and disagree about it. He then says that the evidence presented at trial would appear to present a Gordian knot requiring extensive deliberation to untangle. But that's just his opinion, and it was pretty clear, I think, to most of the world what the verdict needed to be. It wasn't hard to untangle that evidence. A lot of us watched this trial live. There were live chats going, and the majority of people in those live chats felt he was guilty. And guess what? None of us had talked to Becky Hill. None of us had been given instructions by Becky Hill. We're simply intelligent people capable of sifting through this evidence and watching Alex's behavior and determining a true verdict. He then mentions a juror wearing his suit for the first time that day and going on an appearance on TV that night. And then he makes some kind of crazy accusation that it was obviously not his, as it was many sizes too large. So I guess he's critiquing their clothes now too. Was it poor taste for him to appear in a suit thinking he might be interviewed that night? Yes, I will say that. But more importantly, let's back up to where Judge Newman said that admitting the financial crimes was pretty controversial. It's Exhibit B of this document, which is an interview at Cleveland State where he graduated law school. And who is he speaking to? The College of Law School. We see he's introduced by the dean of the school, Dean Fisher. And we see that here in the first page of the transcript. What's the significance? Let's look at the code. They're claiming he broke Canon 3 of the code, but let's look at Canon 3. It says, a judge shall not, while a proceeding is pending or impending in any court, make any public comment that might reasonably be expected to affect its outcome or impair its fairness, or make any non-public comment that might substantially interfere with the fair trial or hearing. But notice what it says. This section does not prohibit judges from making public statements in the course of their official duties, we'll have to remember that, or from explaining for public information the procedures of the court. Did you get it? For public information, the procedures of the court. If we look at the Federal Code of Conduct for United States judges, it specifically mentions speaking at scholarly presentations made for purposes of legal education, where it says, a judge should not make public comment on the merits of a matter pending or impending in any court. The prohibition on public comment on the merits does not extend to public statements made in the course of the judge's official duties, to explanations of court procedures, or to scholarly presentations made for purposes of legal education. Judge Newman's remarks at a scholarly presentation in a law school are exempt from this canon. It's plain and simple right here. Judge Newman did nothing wrong in what he spoke at his alma mater. What else is exempt here? Public statements made in the course of the judge's official duties. So, his speaking to the jurors in his official duty as judge was also exempt. And that's another claim that they've made here. In their writ, they speak of Judge Newman repeatedly expressing disdain for Alex's denial of murdering his own family. Are they so unfamiliar with criminal court that they're not aware this is part of judges' remarks at sentencing hearings? They regularly express their feelings about the convicted defendants before them. Here are two examples: the Chris Watts case that I mentioned earlier, and the other big trial of this year, Lori Vallow. Listen to what these judges say in their sentencing remarks.
The court is going to accept this plea bargain under the circumstances. Words that come to mind when I hear the evidence in this case are a senseless crime and the viciousness of the crime. And equally aggravating in this court's determination is the despicable act of disposing of the bodies in the manner in which they were done in this case. I've been a judicial officer now for starting my 17th year, and I could objectively say that this is perhaps the most inhumane and vicious crime that I have handled out of the thousands of cases that I have seen. And nothing less than a maximum sentence would be appropriate, and anything less than the maximum sentence would depreciate the seriousness of this offense.
Murder is the most serious offense. And the most unimaginable type of murder is to have a mother murdering her own children, and that's exactly what you did. You were involved in and guilty of conspiring to murder another group of children's mother, Tammy Daybell, who had children of her own. And despite the jury convicting you with overwhelming evidence, you still sit here before the court today and said you didn't do it, and moved here from another place already with plans in progress to make your children disappear. The evidence bore that out at trial. You removed your children from their home in Arizona, alienated them from friends and family, got rid of JJ's service dog. You moved to Rexford, a community where you could find 1,000 random families to take your children, and you brought them here to murder them. You had so many other options. You could have gotten divorced. You could have found someone to take care of those kids. But as the state was able to prove at trial, you chose the most evil and destructive path possible. You killed those children, according to the state's theory, and I believe it, to remove them as obstacles and to profit financially. You justified all of this by going down a bizarre religious rabbit hole, and clearly you are still down there. While you were enjoying your new life in Hawaii, countless law enforcement officers, family members, and volunteers were searching for your children. And I don't think to this day you have any remorse for the effort and heartache you caused for others who looked for your children when you knew where they were and knew they were dead. They were found dead, burned, mutilated, and dismembered, and buried like animals. After you knew they were dead, you collected public-funded assistance payments meant for them, and that was blood money you kept for yourself. And that's the grand theft charge you've been convicted of. Your sister, your son talked to you, begged with you while you were in the jail during phone calls I heard at trial, and those were very sad and difficult calls to hear, and you didn't provide any assistance or comfort to them. During the trial, when the evidence came out about how these children were found and the state they were in, you wanted to be excused and not have to watch the evidence, and were fine to let all the other people in the courtroom, including the jurors, have to bear through that. However, I ruled that you did have to sit and watch and see the result of your heinous crimes. The jurors in your case fulfilled their duty admirably, and I do thank the jurors publicly for the service they rendered. Those jurors I noted during the trial were very good at keeping their emotions in check and keeping stone-faced as they're supposed to do and be objective until the case is done and submitted. However, I did note at certain times during the trial, such as when there were videos and pictures shown of you in Hawaii at this time frame when JJ and Tylee were lying in shallow graves, the disgust on the faces of those jurors was evident, and shocking revelations about what happened here just kept coming through the trial. The crime scene was a horrific thing to have to review, and there's images that I will never get out of my mind, and I'm just looking at the pictures. Law enforcement officers who had to deal with the aftermath of what you did, I'm sure were traumatized, and I know it was traumatic as well for the jurors who had to sit through and see the photographs of these dead and mutilated and buried children. For those people who loved and cared about JJ and Tylee and Tammy Daybell, to have to see those photographs of them through trial of their dead and desecrated bodies must have been devastating. Tammy Daybell was murdered as a result of your conspiracy. She was, by all accounts, a healthy, happy mother and wife through a lot of her life, and you were out shopping for wedding rings to marry her husband while she was still alive. You were planning a wedding to her husband while she was still alive. You haven't shown any remorse for any of those actions, and she ended up being murdered, buried, had to be disinterred later so an autopsy could be performed in order to prove the evidence of what you had done. She didn't deserve any of that. You took her life away, you destroyed that family, fractured it to the point where, in the information I've had through the PSI, there are relationships that will probably never be mended that have rippled as a result of what's happened. JJ and Tylee, of course, 7 years old, 16 years old, were separate people whose lives were cut way too short because of you, never got to grow up and be adults. And it is the most shocking thing, really, I can imagine, is that a mother killed her own children and you simply have no remorse for it. Even sitting here today, there's no remorse for what you did. After all of this evidence through trial, you haven't shown any remorse. You haven't said you're sorry. There's been a lot of people during trial and here who explained the devastation you're responsible for, and you've forever altered the lives, not in a good way, for many, many people, destroying family relationships, taking people away that were loved, cared for, and needed. You may not believe to this day that you've done anything wrong, and you still may think you're justified by your religious beliefs for what happened here. I'm not here to judge that, but I don't believe that any God in any religion would want to have this happen, what happened here. And your crimes are heinous and egregious, and that alone can constitute a major aggravating factor that requires me to impose a serious length of incarceration.
They both stated personal opinions of how they perceived these murderers found guilty in their courts. This is a normal court process, and there is nothing wrong with it because, as stated in the code, this is within their official duty as judge. After the verdict was read, Alex was from then on considered a guilty man in the eyes of the law. His presumption of innocence ended with the jury's guilty verdict. There is nothing wrong with a judge speaking of him as guilty. He is, in fact, now guilty in the eyes of the law. Page 6 of this writ goes on about this speech at his alma mater. These points are all moot because it is a scholarly presentation as defined by the federal code and defined even more liberally by the South Carolina code we just looked at, that states that judges are exempt from explaining for public information the procedures of the court. In this document they filed, they specifically say he gave a public interview about the trial at his alma mater, the Cleveland State University College of Law. And he was explaining procedures of the court by talking about how defense opened up and led to his decision to allow the testimony on the financial crimes. Was that not procedures of the court? Him stating this information is teaching future lawyers and future judges how to preside over a trial and also what mistakes to avoid during a trial. Maybe this criticism of their mistake hurts their feelings, but it's not wrong. And this little addition, calling the financial crimes unrelated to the murders, is their wrong opinions. The court did not find them unrelated. They were the motive. Dick and Jim may not like it, but calling them unrelated is not correct. Unless a court overturns that decision, putting this testimony in was completely legal. For the sake of time, I'm going to divide this into 2 parts and stop here for today because this document is so huge, but so important, and as always, I have far too much to say. I also have to give my throat a little bit of a rest till I recover from this. Thank you all so much for your patience. I know you've waited for many days for me to get to this. Part 2 is coming soon. Until then, stay well and stay tuned.